Attorney Leonard, stay right there. I just want to give a brief update. We do have a reporter inside that courtroom right now. That is Anita Blanton, and she just gave us some updates here via text saying that Judge April Perry is actually in the courtroom. She has arrived. There are 2 attorneys for the state, 2 for the city, and 2 for the defendants in this case. And the judge says that she has a lot of questions over this case and expects this to go for quite some time. Several filings apparently came in last night and again this morning. So, of course, this judge has a lot to sort through. The attorneys will have to give their arguments on all of this. So we will probably be following this for quite some time. But I do want to ask, did you want to say something?
I was going to say it could go a while. And, you know, the defendants were supposed to file some of their paperwork last night. But then you had all the amicus briefs. Basically the friend of the court, the folks that are joining in with the plaintiffs here. We mentioned some of these governors.
Right.
We mentioned some former military officials joining in.
And that's what I was going to ask Attorney Leonard, specifically about the amicus brief coming out of California, as you just alluded to, Paris. Attorney Leonard, these amicus briefs that we see, how do they help, a case of this magnitude? Do they actually help? And is there any legal precedent that has been set in cases, maybe not similar to this because we are in new territory, but in cases where other states, other people join in to really support the overall argument?
Yeah, it's very common. Amicus brief is otherwise known as a friend of the court, and it arises in when you have a particularly important or significant issue that is bigger than just the jurisdiction you're in. So it made sense that other states like California would want to submit briefs in support of the state of Illinois and city of Chicago, and other states as well, because they're all facing the very same issue. Whether the court really will focus on those, I would doubt it. I mean, you got to look at kind of the practicalities of this. So the friends of the court briefs were filed real recently. I think the judge's focus is going to be, number one, on the pleading, the 69-page document, and then the defendant's response brief to that. But perhaps more importantly, she's allotted, if you look at her docket, she's allotted, it looks like 10 minutes for oral argument from one side, 10 from the other. And again, they're limited to legal arguments. They're not presenting witness testimony. And then she's allotted an undefined period of time for her to ask questions. And then when she's done with that, which I think that'll take a long time, it's kind of like an appellate oral argument is what she's doing. Then she'll allow for closing arguments by both sides. And I'm sure that after she asks those questions for all those hours and they take a lunch break and all that sort of stuff, that we're probably talking about closing arguments towards the end of the day, and therefore maybe an opinion issued maybe tomorrow. But this is really kind of proceeding like almost like an appeal, because what the judge is going to want to do, she's going to want to ask pointed questions and get the parties to make admissions to the point she's making so they can use those, kind of for or against them in the ruling that she makes.
And we know from Anita in the courtroom that the state has started its opening argument, basically saying troops are here, they're going to be sent to the courthouse, and this is about a balance of state power against the federal government here, that this is throwing that way out of whack. What happens here in the case that Judge Perry, and boy, this does look like it's going to go on a long time, if she rules for the TRO, but the defendants don't remove the National Guard troops? I mean, that's where we find ourselves in the constitutional crisis, no?
Yeah, I mean, that's a great point. I mean, that literally could happen, so the judge could rule and the troops could remain. And then the question is, what do you do? Obviously, they would be in contempt of court at that point, and they could be essentially brought before the court physically. But yeah, what do you do in a situation where you actually have federal troops? Are you really going to take steps with Illinois State Police and others to try to remove them? I doubt it. But hopefully it doesn't come to that. We don't have what you're calling a constitutional crisis.
Because it's interesting. Oh, sorry, T, you wanted to jump in. I was just going to say that Judge Perry had said in that Monday hearing that she had advised them not to be deployed.
And that was going to be my question to Attorney Leonard, because I'm reading these texts. I don't want people to think we're being rude as we hold our phones, but this is how we're getting information from inside the courtroom. And there are questions about, the troops are here. That is something that is literally in this text. Tomorrow, like you said, Paris, they're being sent to the courthouse. Will the judge weigh the fact that we have seen the National Guard show up at the Broadview ICE facility? Will that come into play here?
Well, first of all, when she made that sort of statement, I guess, at the status hearing, that's not binding upon anybody, but it's certainly something that most parties would listen to when a federal court gives you an admonition like, hey, I don't want you to do this, even though it's not an official ruling. Most people stand down and don't do that. So I think that will probably irk her. Will it play any role in her decision? I don't know. I think she's still going to stick to the law and the facts. You made a point earlier about her, sort of ascendancy to the bench. She is very new to the bench. She's kind of a blank slate in terms of written opinions. All of her experience has been either as a federal prosecutor in that building and then a state prosecutor at 26 in California. So this is something entirely new to her. And, I guess lucky that she has a lot of precedent. She'll have a lot to work with, with all the legal teams and all the arguments that are being presented. But I do still think she's going to come out in favor of the plaintiffs.
I want to read some other information that's coming in out of the courthouse right now. A presidential memorandum came in at 11:34 last night, claiming president is unable to execute laws in Illinois. The question has been raised, where's the rebellion? Are they well armed? I'm guessing that is in terms of talking about maybe the protesters in this situation. Does the president consider this a judicial insurrection? Brazen disregard for actual conditions on the ground in Illinois, and protesters at Broadview crossing the line into violence and crime are being prosecuted. So what's not being enforced in Illinois? These are direct quotes. This is not me. This is coming out of the court.
These are direct quotes from the state's argument. But, I have to say, and we talked about this last night on Chicago Report, but a lot of the protesters that were taken in and federally indicted, the charges were dropped.
They were?
Yeah.
The prosecutors didn't even follow through with them. So you've got that aspect of it, that they are arresting folks that cross the line into violence, and in many cases, they don't have a case against these folks. So it pours cold water on the notion that the president can't carry out the law here, or that they're being overwhelmed. But I'm just curious, Michael, the judge in Oregon ruled on the TRO right away, and Judge Perry here wanted to take some time to have arguments and look at the brief. Why do you think that was, the discrepancy?
I think that's a wise choice. I mean, it's very common. I mean, typically, particularly with an issue of this magnitude, you're not going to just rule on the papers. You could do it, but I think it behooves any court to have argument, let everyone make any argument they want, submit any brief or argument they want, consider it all, or at least give the appearance of considering it all, and then make your ruling. I don't see any reason why there was any extraordinary circumstance that she needed to rule just on the papers without a hearing. So there's nothing particularly unusual about that. She could have approached it that way, but I think the way she's doing is probably the better course.
It sounds like, Attorney Leonard, you think this is going to spill over maybe until tomorrow, maybe until next week.
So maybe we don't have a ruling today.
Yeah, what are your thoughts behind really the timeline here?
Yeah, I wouldn't be surprised if there's not a written ruling today, but I think that would still come tomorrow. So I think the arguments are going to be lengthy. The questions are going to be long, but I can't imagine she's going to go on for more than 2, 3, 4 hours with questions and answers. But that would be a real long time. But and then I think she gave 15 minutes to each party for closing arguments. So there's no reason that all the arguments in questioning can't be completed today. What I was saying is maybe the written ruling doesn't come till tonight or tomorrow. But I think she's indicated and already kind of telegraphed that she wants to issue a ruling today. So it's certainly possible to do that today. I mean, she's obviously going to go into this hearing with a set of issues that you can already start drafting a memorandum opinion. You know what the issues are. You kind of have them teed up in your opinion, and then it's not fill in the blanks, but obviously you're going to use facts from the complaint. You're going to use arguments from the briefs, and you're going to use statements or admissions made by the attorneys during the arguments today. So it's not like it can't be done. So I wouldn't be surprised if it could still come out tonight or certainly tomorrow.
I'm looking at, we talked about this court filing and mentioning, all of the pages, some of the examples in there. And actually on page 29, it's interesting that the city of Chicago and also the state of Illinois, they have a picture of what is a group of DHS agents, around 100. They're standing literally outside of Millennium Park and on Michigan Avenue. And they say they're positioning themselves in large groups on major pedestrian thoroughfares. This is a direct, statement coming from this lawsuit in tourist and commercial areas, and you literally see them just standing. What do you make of the state and the city pointing to some of these examples of, these federal agents being here And there's no movement. There's no one in this particular picture that I'm looking at. There's no one in their face. There's no disregard, at least in this particular instance, of federal authority. What do you think of some of these examples of that are throughout the lawsuit? Because you mentioned seeing some of those as well for yourself.
Yeah, I think the state and the city, their lawyers did a really effective job of their complaint. First of all, it is lengthy. It's 69 pages, but there's 10 or more legal counts. Those are the claims they're seeking relief upon. But what they really did an effective job was in the factual background. They did a great job with the facts. They set it up with, hey, the Trump administration, the Department of Defense, Homeland Security, they've made all these public statements against Chicago. They included, graphic postings the president has made. And then they really dug into like, hey, what are these troops doing here? There's no insurrection, there's no rebellion. They made it very fact specific. And of course, in a complaint, it could be bare bones. It could have been a 5-page complaint if they wanted it to, but it's a very persuasive document when you read it, and particularly persuasive to a court, they would hope. And it's also a PR piece. They know everyone's going to be reading it. So I think it was a very effective use of the facts and, putting the Trump administration and the agents on the ground sort of in a bad light, or a light that leads to the conclusion that it doesn't make any sense why they should be here.
And to follow up on that exact point, and we're getting some dispatches from the courtroom and the state's arguments, but basically saying that the state police claimed that ICE officials reached out to them before the troops arrived and said everything was under control. They have an email in their exhibits here showing that ICE officials said they were grateful for the help from the state police. So again, just kind of making the case that the facts on the ground don't comport to what the Trump administration has said. And that's kind of what the judge in Oregon had said, Judge Immergut, basically, that the claims from the Trump administration don't comport to the reality on the ground. And so, again, a similar argument being made by the state of Illinois here, that there's even email correspondence from ICE officials saying that the state police have, once they came in and kind of brought some order to these protests out here, things were very orderly, and there really is no danger in carrying out their missions. Especially
considering, because you said you were out there, and I think you were out there the day that barricades were brought up in Broadview. It really separated the ICE agents in some regard from the actual protesters. So when you were out there, were you able to see protesters? Because before they were able to get face-to-face, almost nose-to-nose in some cases, when the ICE agents would come out. And then that fencing was erected there, and then there's a legal challenge on that fencing. But yeah, the state police, the governor called in the state police, and he made a point of they're there to protect the right to protest. But when we were there, the state police, and some of the protesters were upset. It seemed like the state police were there trying to just sort of provide some cover for the federal agents to carry out their mission. Now, there might have been some anger at Governor Pritzker over that, but if you look at it from a legal context, it's helping the state's argument here that things are okay, because the state police got out there, they brought some order to the protests, and there really never have been huge numbers of protesters. It's been a few dozen, and sometimes they've gotten violent, but the state police here helping the federal agents carry out. I mean, that's what the blockades are there for, so that the cars can go in and out, so there's no blocking of that. So it's a very orderly situation now, as opposed to the way it's been for the first couple of weeks. But yeah, Tia, you wanted to... Yeah, because I'm looking at more text that kind of supports what you're saying. They're talking about the sporadic protests. This is going on inside the courtroom right now. Sporadic protests, criminal misconduct directed at officials in Chicago, and they cite Superintendent Larry Snelling, that is the superintendent of the Chicago Police Department, refuting of characterization that CPD refused to help. We've talked about that before. Well, and that's interesting, too, because that... I would guess that's going to be a big part of the argument from the federal government, that this issue that police patrols were ordered not to respond when ICE agents had called, and Snelling through that press conference and said that did not happen. The order did not come from the chief of patrol, and And that the chief wouldn't have ignored the order if it did come through.
Well, maybe I should pose that question. Mike, what do you think about that as a potential argument from the defense? This issue that the patrols were ordered not to respond when ICE agents called over the weekend, although they did end up on the scene about 40 minutes later.
Yeah, I mean, I think that would be an effective argument if that were true. It doesn't seem to have a lot of footing to it. I mean, with ISP, Cook County Sheriff, CPD, all basically saying, hey, things are under control, and having communications with ICE about those subjects, I think it really undermines the defendant's arguments that things are out of control, number one, and that number two, they're not getting the help they need to enforce federal law. I think that memorandum you spoke about a minute ago that you said was just filed or recently filed this morning, I think that was an attempt to kind of get at that prong of the law that said, hey, if the regular forces aren't enough to enforce federal law, we can bring in the National Guard, which clearly does not seem to be the case. But that's an attempt to try to somehow shoestring their arguments into the federal statute that applies to the situation.
And it looks like we've got some, the defense is now giving their opening statements, and to summarize what they're saying there's tragic lawlessness in Chicago. Officers are met with resistance. Improvised explosive device recently found in Broadview. ICE spent $100,000 used in combat. There was a bounty on the head of one official that's been reported. Ramming of vehicles, rioters gathering off-site and brought to Broadview to physically engage, and they're saying that the violence in Chicago is quickly eclipsing what they saw in L.A., where they called the federal guard, the National Guard there, although the judge had ruled that also was unlawful, although did not rule that they had to disperse right away.
And what you're saying, the defendant speaking inside of the courtroom, they're saying those facts alone establish need for federalization. Based on what Parrish just read to you, Mr. Leonard, what is your take on that? Do you believe that is enough to establish need for federalization, or does there need to be more?
I think there needs to be more. I mean, first, the judge will have to first address the issue. Was there even the authority to do this? Did it have to go through the governor? She may, that may end the issue right there, in her opinion. Number two, is an appropriate use of the forces, which I don't think it is under the law. It is something that by the law on its face and by precedent is invasion, rebellion, things of that nature. And then the other issue is that even if they could be here, they can't engage in what are really law enforcement activities. So I think for all of those reasons, I think Perry is going to rule in favor of the plaintiffs. And the way it's moving, as you're describing it, maybe if Judge Perry only has an hour or two of questions, we will get that written opinion today or tonight. And, she could also rule from the bench, indicating that here's what she's doing. Written opinion will follow. So that definitely could still happen today.
Oh, that's interesting. So she could make an oral ruling from the bench with the written opinion to follow. And is there some kind of alternate ruling where she, I was kind of confused in terms of what the ruling was in Los Angeles, where she can grant the TRO, but then also say that they don't have to go home right away. I mean, what was that ruling in L.A.? Because it's unclear.
Yeah, I'm not too familiar with that one. I mean, basically what she should be doing is either granting preliminary injunctive relief, the TRO, or denying it. Okay, if she denies it, then the case can still proceed on its merits. There still is a lawsuit pending, but the extraordinary relief, meaning stop things in their tracks, maintain the status quo, that wouldn't be the issue. So I expect her either to grant it or deny it. I don't think there's going to be any in between here. And then the question is going to be, will either side have the ability to immediately appeal it on what's called an interlocutory basis or by way of mandamus or not? Will they have to wait until there's an actual full-blown hearing with witness testimony and evidence offered, or whether, that none of that may happen. The parties are going to have to make strategic moves based upon what Judge Perry does today. But I would expect the Trump administration, if they get the TRO entered against them, that they're going to want to get in front of an appellate court by any means necessary and as fast as they can.
It was just brought up in the courtroom, the case of Martin versus Mott, in which the Supreme Court case concerning the President of the United States using emergency powers. Are you familiar with that particular case, Mr. Leonard? And I guess it begs the question here, in what they're trying to sort out, is, did the president have the sole authority in this case to decide when to call up the National Guard?
Correct. Yeah, and I don't think this certainly fits the emergency that they're citing, but I don't think it still gets them around the law. And even if it gets the troops here, what they can be used for is very limited. So I still think that they're based upon the law, the facts, the Constitution, the federal statutes at issue. I think that the defendants still have the losing hand here. So I would still expect, Judge Perry to rule in favor of the plaintiffs.
You hear all this kind of saber rattling about the Insurrection Act. If the president were to come out and just declare the Insurrection Act, what do you think would happen then?
Well, we'd be litigating that. So,
exactly.
But again, I don't think it applies. I mean, this is far from an insurrection, and insurrection is the level of someone moving against the government, someone taking action against the government as if to almost overthrow the system. So the fact that you have protests, they may be out of hand in some respects in some points in time. I mean, this is tame to a lot of the stuff we've seen historically here, even over the last 5-10 years. So I think they're really reaching, but of course they're going to reach. They're going to make every argument they can to fit the president's actions within any statute, executive order, any precedents they can get their hands on. So it's not surprising the defense is raising, new and somewhat novel arguments. That's their job.
And the defense just said as well that it doesn't have to be actual rebellion to federalize. President should be able to prevent acting in danger of rebellion. Also citing 10th Amendment claim does not apply to valid federal action.
President should be able to prevent.
I
mean,
right.
Whether they think they should or should not, there's a constitution. There's
right.
a federal apparatus of laws.
What do you make of that?
Well, I was just going to say, if regular forces aren't sufficient to enforce the law, Michael, can you just explain that little clause a little bit? Because that seems to be a bit of a gray area.
Yeah, that's something that really hasn't seemed to have been litigated at all. So you have the two prongs that really seem to limit it to, rebellion, insurrection. And then there's other clause that says that the National Guard troops could be called up if regular troops are not sufficient to enforce federal law. I mean, on the face, I read that as regular troops, meaning the regular armed services. So I don't know if that even applies either, but they're of course going to try to argue under any prong of the statute that they can, or any constitutional argument that's different than the statute, because it gives them more breadth to argue if you can broadly argue generically under different constitutional provisions about the power of the president, the use of militia, the role of state sovereignty, and how the federal government usurps that in certain situations. So they're going to make all sorts of, hopefully well-founded attacks or good faith attacks based upon the Constitution. But ultimately, I think, again, the plaintiffs certainly seem to have the upper hand.
It's interesting that you say that because as just happened in court, the defense is arguing that the deployment is lawful. Like you said, they will try to argue their point. They're saying that it is lawful, it is within the authority, and it is responding to urgent, serious, and ongoing threat. But I guess us being here on the ground so far, kind of like what you said, Attorney Leonard, we haven't really seen that. We haven't seen that magnitude of threat. So that is something, right, Attorney Leonard, that they will have to prove in court. They will have to show examples.
Right. Well, and I think they already brought up the cars being rammed over the weekend. That might be one example. Although, when that phone call was made to call the police, the dispatch mentioned that these are 30 armed ICE agents here asking for some backup. So it's not as if they are protected there. And also, the president does have the ability, if he believes that they need backup, he can call other federal agents. He can call ATF. He can call FBI. He could call further immigration agents. Correct, Michael? I mean, there are other agents that are within the law, the president's purview to call up that aren't military.
Oh, absolutely. There's a whole horde of federal agencies, from the FBI to Homeland Security to ICE agents. I mean, there's a lot of people that could be called up before the National Guard. This is clearly a political move, a show of strength, kind of a test of the courts, and particularly when you're reaching into another state, the state of Texas, who you're strongly aligned with politically, to try to bring their troops here. That's a certain political statement that you're making by doing that. So clearly here you got even got ISP, Illinois State Police, you got Cook County Sheriff. So it doesn't factually seem like a scenario that fits kind of the picture they're trying to build. And I think it's interesting if you look at Judge Perry's background and how she'll come to this case. You know, her background is in law enforcement, has been really exclusively as a prosecutor. So she understands police, she understands law enforcement, she understands all the various levels and layers of agency. So I think she's probably well situated to take on those arguments and really, you know, have a really good understanding whether they make sense or not from the practicalities of on the ground. I think she's in a great position to not be hoodwinked or to understand, you know, what they're saying.
Attorney Michael Leonard, federal criminal defense attorney, we really appreciate you staying with us. You stayed with us for quite some time, to give us some perspective, and we appreciate your time today.
Thanks, guys. Real appreciate it. I'll be looking forward to the opinion just like you, but your analysis seems to be right on. Thank you.
Yours as well. Thank you so much.